Push button, there I go, okay. Thank you all. Most of you, I think, know me, so I'm not going to spend time telling you who I am. My stuff is up there. I'm a law professor at the University of Denver Stern College of Law. I teach Indigenous Peoples, International and Human Rights Law, as well as what I call Earth Jurisprudence, which is Earth Law. And but I spend most of my time as a practicing international lawyer, a little bit of federal Indian law. I spent 40 years or 30 years or so on federal Indian law. In doing that, I've been tribal counsel for the Oglala's fighting the Crow Butte mine off and on for 40 years. And during the last half of that time, I got to know Harold Dean pretty well. And I just got to say, that man's invincible. I think he's beat every single disease known to man, and probably some that aren't known to man. And he's still with us. And it's been a real honor to get to know him. He's my mentor. And he's taught me compassion and humility, which are two big things, hard things for lawyers to learn. So thank you, Harold. Yeah. Also, Andrea is one of my mentors as well, as Steve, who was on here before. Lawyers are stupid. I don't know how do you say stupid in Lakota? Anyone know? But just shout it out. But stupid wasichus, and we need to be reined in. You don't have to be smart to become a lawyer. You just have to play the game. And so it's important for the people that we work with to keep us in line. So what I wanted to talk about today, and I usually talk about colonialism and all that. I didn't really want to cover that. I think I don't want to bore you with us talking about the same stuff over and over again. I'm happy to answer questions on that. That's my main area, is decolonization and getting rid of imperialism and colonial rule. But there's some things coming up that are very serious that'll affect Indian country and native sovereignty. And I think you need to know about it. Some of you probably heard about it, but I wanted to go through those. And one of the reasons why they're so important is because they threaten the legal existence of Native nations, the legal sovereignty. There's several matters. There's one before the U.S. Supreme Court right now on the Indian Child Welfare Act called the Brackeen case. And there's some others coming up that are there's a concerted effort now to attack Native sovereignty and to get this conservative court that's up there right now, anti-Indian court, that's there right now to throw out Native sovereignty. What they want to do is turn Native peoples into ethnic communities of the United States and take away their sovereignty and their autonomy, their self-rule and so forth. So I call it judicial termination. Some of you like me are old enough to know about the Termination Act in the 1950s, where Congress just simply went about terminating Native peoples and just said, you don't exist anymore. You're American citizens just like the rest of us. I did some of my early work with the Menominees, and they were one of the ones that were terminated, and were able to get the recognition, the reservation, their lands back. But they lost their most sacred lands, Legend Lake area on the reservation. About a quarter of the reservation they lost during termination, and it was the area of the reservation that was where they went for healing. One of the things I wanted to note on this is, you'll see up here this law firm up here, these guys up here on the right. It's Gibson Dunn, and they were the attorneys that handled there's a fairly recent decision of the courts where they terminated the Mashpee tribe. They said, you don't exist anymore. Said, you don't exist. Yeah, they were sitting in the courtroom. They said, you don't exist. And that case was brought by these guys here from this law firm, Gibson Dunn, one of the larger law firms in the country. And so some of you probably know about McGirt, which is the one where the Muskogee Creek were able to get their recognition of their jurisdictional reservation boundaries, their territory, which includes Tulsa, Oklahoma now and some other places. But this is that decision here, and everyone talks about how great it is. Oh, it's wonderful because the government didn't terminate the territory of the Creek Nation. They actually recognized the boundaries. Well, the sad part about this is right down there at the bottom, where Justice Gorsuch, who wrote that decision, says right down after Rex says, oh yeah, we didn't terminate the territorial boundaries. He goes on to say, yeah, but Congress can do it anytime they want to. Anytime they want to. And everyone, you talk to all these Indian lawyers and they all talk about what a great case the McGirt case is, but they kind of ignore that last little bit right at the end. And sure enough, what happened, then they had the distinguishment of the Comanche territory. This is recent, December 30th, 2021. The federal court there said that the Comanche no longer exist. They no longer have a territory. So they're completely under state rule now. That's disappeared. And then recently, this is just, what do we have? December of 2022. It's only a few months ago. They made the same ruling for the Cheyenne and Arapaho people. So there's this process of termination now, judicial termination, that they're starting to terminate the rights. And of course, when they terminate tribal jurisdiction, what do? They terminate your sovereignty. They terminate your self-rule. They terminate your ability to control what happens with your resources, with your water and your people, and so forth. And you may, obviously, we all remember Dakota Access, Standing Rock, right? Who was behind that? Well, here's the owner of Dakota Access Pipeline, a billionaire, right? Who do you think represented him? The same law firm, Gibson Dunn. And this law firm turned around and they represented this guy in Dapple in the various litigation. And one of the cases they bought was they turned around and sued all the protesters, all the people involved in the protest under RICO, racketeering, saying that everyone had gotten together and conspired against Dapple and to destroy them. And they then violated federal law and so forth, turned around. It's called a slap action, where they try to shut you down so you can't talk. Who brought that lawsuit? It was Gibson Dunn. And then you may remember or heard about this case in Ecuador and New York, where where the native people in Ecuador, some 30 or 40,000 people died because of oil contamination in native country in Ecuador, right? Wiped them out. It's ecological genocide, corporate genocide, Chevron. And so they sued and they got an $18 million judgment. It was reduced by the Ecuadorian Supreme Court to $8 million. The guy that brought this is this guy here, Stephen Donziger, right? He's a New York lawyer, went down right out of Harvard Law School, went down there and tried to litigate this. He made a bunch of mistakes in the litigation, serious mistakes. And there's a movie out called Crude, where you can watch this and see what happens. And I won't go into that. I can answer questions if you want. But what happened was then the same group up there, there's a boycott there, Gibson Dunn, they represented Chevron. And instead of actually attacking the merits of the lawsuit, they went after the lawyer and the way the litigation was done. They were convinced that it was fraud, and they threw the $8 billion judgment out, which means that the victims haven't received a dime again. So it's essentially a slap lawsuit. And they actually had this lawyer here. He was kept in home detention for over 2 years. He couldn't leave his house, and he is still being litigated today. Now the same law firm now is bringing this Brad King case that's before the U.S. Supreme Court, Gibson Dunn, right? And I'll get into this further, but it's raising questions about whether or not the Indian Child Welfare Act is constitutional. They want to get the Indian Child Welfare Act thrown out. And so, but why? And by the way, this law firm, and you'll see this Gibson Dunn up there, this law firm isn't getting paid. They're doing it for free. And this is a big case before the U.S. Supreme Court. It involves 3 families that are trying to adopt Indian kids. 3 white fundamentalist Christian families. And one's already adopted 2, another one is trying, and the others are trying to adopt them. But the Brackens are represented by the same law firm that represented these others. And so there's an issue. So they're using this Indian Child Welfare, the argument that they're making, I'll talk some more about this later. The argument that they're making is that this discriminates against white people. The Indian Child Welfare Act discriminates against white people. And they're saying that Native people should not have special rights, that equal protection violates their rights, and that and therefore they're arguing, and what the tribes are arguing is, no, we're sovereign people. These are our children. We have rights because of our sovereignty. So this case is being used to attack Native sovereignty, and they're asking the U.S. Supreme Court to throw out as a matter of law Native sovereignty, and to treat Indian people the same as all other people in the United States, where you do not have any rights as sovereigns. So, and if they do that, if they're successful, what do they get out of that? It opens up Indian territory for exploitation by these big companies, by the oil companies. They can come in and they no longer have to fight tribes. There's no more Dakota access struggle. There's no more Standing Rock if they get this. So I wanted to do a little background on the NHL Welfare Act. I've been doing some work on this. I prepared a brief in that Supreme Court case, which I pulled for various reasons. I'll talk about that later. But I'm writing a law review. I've been asked to write a law review article on that, so I'm going to do some of this. But I wanted to give you some background on this whole thing of child theft. It started with Columbus. Columbus took a bunch of Native people when he came here in 1492. He took a bunch of Native people back to England as examples of slaves. He said, "Oh, these guys are going to make really good slaves. There's money in that." And so, but he also took women and children. And then when they passed these first laws, this was done by Diego Columbus in 1512, who was the son of Christopher Columbus. When they passed this first law, one of the things they put in that is called the Leyes of Burgos, or the Laws of Burgos. And it was supposed to regulate Indian slaves. And first off, it compelled all Spanish plantations to have at least 100 slaves. You had to have 100 or more. But then they put also in these laws that the slave owners, they had to convert Native people. So this was all done with the Christian church, right? There was only one church at that time, just the Catholics, right? It's called the Universal Church. And so these are the laws of the church. There wasn't separation between church and state. So whoever had slaves then had to forcibly convert them to Christianity, the Christian church, by putting up churches and so forth. But one of the things that they do is they said that you had to take the child from the Native people, bring them into the white community or Spanish community and teach them Christianity the white way and Spanish, and then send him back in his community, and he was supposed to then convert everybody to the Spanish way. And then there was another provision later on about the sons of chiefs. So you took the son of the chief and you kept him until he's 19 years old, and you put him with the priest until he's 19, and he serves as a slave to the priest, and he learns Christianity, and he learns Jesus, and he learns Spanish, and he learns the ways of the white people. And then he's supposed to send back and teach his people that. So this is one of the reasons why what Steve Newcomb was talking about earlier in terms of this repudiation is a joke. The church says, "Oh, we weren't involved in that." They said it was politics. We issued those papal bulls, but we didn't intend it to be used that way. And they're saying that that it was a political thing that the Spain and Portugal and others did when they did that. But no, the Catholics were no saints. This guy over here, Juniper Serra, was recently made a saint by Pope Francis, who's considered a very progressive, open-minded pope. But Juniper Serra was very famous because he put missions all along the coast of the western coast of the Pacific, from Baja California up to San Francisco. But he built each one of those missions he built with slaves. And then he kept children as slaves through that. And he's considered to be a model, a saint within the Catholic Church. And there were protests and so forth, but Pope Francis made him a saint anyway. And during all this period, for some 300 years or more after this, after the papal bulls, and even after the 1537, which Steve talked about, when the Pope said, "Oh yeah, we got rid of slavery in 1537 of Indians." That's simply not true, because for 300 years they continued slavery. And there's a whole nation of indigenous people called the Genizaro people. And they're down, they're the people of Mexico. Most of the people in Mexico in the 1800s were descendants of the Genizaro people, which were the slaves. There were Navajos, Utes, and Comanches, Apaches that were taken by the Spanish and then used as slaves and sold as slaves and sold into slavery. And they liked women and children. They were worth 10 times more than a man. And they put them into slavery. And their descendants are still there. And they've organized and have a nation down in near Abiquiu, New Mexico. And so anyway, so there were some, I think it was over 100 or 200,000 slaves that were taken during that time. So during this time of the Genizaro, the Spanish were taking the slaves, you had the Mormons coming in, right? And for the Mormons, they decided that the native people were descendants of somebody from the Book of Mormon. The son of Lehi, whose name was Laman. And he was supposed to be a bad guy, was a wicked person. And so supposedly God made his skin dark, blackened him, right? That's in the Mormon Bible. And so here's this wicked race of people that came up through the Mormon Bible. And then later on, they got converted and changed and became good people. And so the Mormons had this whole thing in the Book of Mormons that talk about, well, we need to bring these people back. We need to include them within our religion. And so you see there's Joseph Smith up there preaching to the native people, telling them why they need to become Mormons. And then later on, and so this process went on for 100 years or so while the Mormons were settling there in Utah and Idaho. And they were bringing in these Indian kids. And so what they would do is they would actually buy the slaves from the Spanish, the Genizaro, buy them from the Spanish and incorporate them within their main Mormon communities, and then they would be adopted by Mormon families. And this went on for a long time. By the 1970s, just in that period in the 1970s, they had adopted over 50,000 native children. 50,000 native children. And that's just the Mormons. They set up a thing called it was an Indian adoptions program with the United States, and with these adoption agencies. Almost all were run by religious people, Christian people, to get native children and adopt them out. So there, I don't know, 100, 200,000 native children that were adopted out during the 20th century. So, but the tribe was called the Lamanites, and you see them here, and they have some more interesting people. Canada, were also doing this, and this is a case that I've been working on before the Inter-American Commission on Human Rights. This is Lonnie Edmonds, and she's a member of the Lilwat tribe in British Columbia, the Wet'suwet'en people. They're the ones that are opposing the pipeline up there in British Columbia. Well, Lonnie Edmonds had 6 children, and they were all taken from her by social services. All of them, because she was considered to be an unfit mother, mostly because she was poor, being penalized for being poor. Why was she poor? She was poor because her people were colonized and destroyed. The economies were destroyed. She was poor, right? And so we filed this action in 1989. Not we, but the organization I'm working with filed the action on her behalf, and there was a decision on admissibility. We're still waiting for a decision on the merits in 2007 that talks about this, but that's that case there. And it's one of the issues that they're arguing there is the Lilwat people never signed a treaty with Canada. And so they were saying, well, because we never signed a treaty and we're never at war with you, you never beat us in a war, then you have no jurisdiction. We're not part of Canada. We're still on our original ancestral grounds. We're separate people. And so we raised that argument in this case. The Inter-American Commission refused to hear that, but they're going ahead and hearing it on the rights of women and children as a matter of international law. So it should be an interesting decision on the application of international law to Native children. And of course, you had the boarding schools in the United States, Canada, and Australia that stole Indian children. Recently, there's a recent article just came out a few weeks ago or last week about Catholic boarding schools. And they've determined that here it says 74, but I think it was up to 87 of the boarding schools run by the Catholic Church where they stole Indian children. So of course, you know what the Pope says, it had nothing to do with them. So there were thefts of political children in Chile. It happened after Allende was overthrown and Pinochet was put in. They stole the children of the opposition and adopted them out. Now, recently you've heard about this war going on between Ukraine and Russia. Russia has this idea that Ukraine doesn't exist. They're Russian people, and that the whole concept of a Ukrainian separate people is a myth, and that they're all Russians. And so what they're trying to do is to destroy the Ukrainian people, genocide. And one of the ways they're doing that is there's in war, when they encounter a Ukrainian kid, they capture them and take them. And they've stolen, I think it's 10,000 children already in this Ukrainian war, and taking them over into Russia. They take them out of Ukraine into Russia and putting them with Russian families. And Chinese are famous for this too. Recently, there was a report out about the Chinese setting up these massive boarding schools in Tibet, where they're putting over 1 million children, 1 million Tibetan children, they're putting in boarding schools. And they're not being taught in their native tongue of Tibetan, but they're being taught Han Chinese. And being taught to be Chinese, not to be Tibetan. They're saying you're not Tibetan, you're Chinese. And Chinese also claim Tibet as part of the ancestral lands of China, which is false. Tibet was a sovereign nation at one point, actually had treaties and embassies and so forth. They had a short war with China, in which China took them over. And that's when the Dalai Lama fled Tibet. And they have a government in exile, but China still claims Tibet as part of China. And it's also happening in the Uyghur territory, which is in Western China. And these are over 1 million people have been put into essentially put into camps, retraining camps, and they're taking children too. And they're setting up schools where they're teaching children in Chinese, not in Uyghur. And it's been referred to as genocide from there. So obviously the purpose of this is to assimilate, to end the separate nature of indigenous people, native people. And so we call that ethnic cleansing or culturecide. Here is a picture. This is from Australia, right? And this is one of the ones that they used, I think, in the 1970s or 60s. They were showing that, oh yeah, we take these kids out, we put them into white homes, and within 1 or 2 generations, they become white. This is what they wanted to do. This is the whole object. And to them, they're helping Native children. They're making them better by making them white. This is good to them. And so it's culturecide, ethnocide. I call it slow genocide in my mind. The Genocide Convention of 1948, on the last provision where they define, well, what is genocide? The last one they say down at the bottom there says forcibly transferring children of this group to another group. That's genocide. So what the Indian Child Welfare Act was stopping was genocide. And if the Supreme Court throws out the Indian Child Welfare Act, they're allowing genocide to continue. Do you follow me? That's why this is an important case. All right. So I saw this, I don't know if it's Kiwasichiaye, assimilation in Lakota, and it's genocide. So that's why they had the Indian Child Welfare Act. So it's not primarily what the Mormons were doing after they adopted out after they took. You see, the Mormons, they controlled the courts. All the judges were Mormons. All the attorneys were Mormons. All the social services workers were Mormons and Christians, right? And so they controlled the whole process. So they could walk into a native reservation anywhere in the Southwest and say that mother going to the hospital had 5 kids. She can't handle anymore. She has 3 kids. She can't handle anymore. She lives in poverty. She can't handle anymore. She's an alcoholic. She can't handle anymore. And just take those kids out and adopt them out. And that's what the Mormons were doing. 50,000 or 100,000 children. And so the Indian Child Welfare Act in 1978 was meant to stop that. And so that's existed now for some 50 years or so, right? Now, all of a sudden, this oil company lawyers come here, and out of the goodness of their heart, they decided that they're going to help these white families get Indian kids because they say it discriminates against whites. And so they bring this case called Brackeen, and there's 2 other cases along with that. And it's in Texas. So they go to one of the more conservative parts of the countries where I frankly hate Indians. They go there and they go to this court and they raise this issue. You'll see the family down there on the left. That's the Brackeen family. And no, I'm sorry, that the Brackeen family is here on the right, and the Native children are there in the middle. There's two of them. And then you see this other family here on the left over there, where they're complaining, foster child ripped from home by the Indian Child Welfare Act. Poor white people were losing their child because then the Indian Child Welfare Act forced them to give it up so that the child could be brought back to the tribe and put within their community. And so, and they have this whole concept, well, the courts are misusing the Indian Child Welfare Act by taking children that in the best interest of the child will have money, they'll have nice clothes and be sent to good schools and all this. Best interest of the child is in a white family. Therefore, they're misusing the Indian Child Welfare Act by putting the interests of the tribe, putting the interests of the child's people over the welfare of that child. It's just their argument. Now, one of the areas that this has come in, so what they're arguing is that the individual rights of white people is more important than the collective rights of Native people, as well as the national rights, sovereign rights. And that came up before in a case called Baki, where the Supreme Court was faced with this deal where under the old, most of you are probably old enough to remember when we had affirmative action programs, where if you were a person of color, you got a leg up to get into a house loan or into a college or, all sorts of benefits you got. And it was to correct historic discrimination. So if you were Black, if you were handicapped, if you were a woman, you were given a benefit because you had been discriminated against for 100, 200, 300 years, right? So that case came before. There were 4 white people that couldn't get into law school because they were white, whereas they let in other people that made lower scores on the entrance exams in. And that case came up before U.S. Supreme Court. U.S. Supreme Court said, oh, that discriminates against white people. It violates the right to equal protection, the individual right to equal protection, and that we don't recognize collective rights to equal protection, so we're going to throw out the affirmative action program. So that's why they don't exist anymore, because of that. Reverse racism. And so that's the Baki versus Board of Regents case. Now in Australia, the same situation came up involving Native people. The people up at the islands you see, there's a little hair lip or hair thing on the islands of Australia that kind of shoots up. There's a group of people that live up there, and a developer wanted to go up there and develop some of their land. And they were saying, oh, that's our land, it's not your land. And the guy was saying, well, I have title to it. So my individual right to property, you can't stop my individual right to property to develop my land. And Native people were saying, that's our sacred land, that's our ancestral land, that's our land. They're called the Torres Straits people, they're up there. And so one of them, Mr. Mabo here, took the lead on that, and he challenged that. And there's two decisions came out of that litigation. The first one's known as Mabo 1. And in that one, the court looked at this and they said, well, which way should we go? Are we going to go recognize the rights of Native people, collective rights to their land? Don't they have an equal right to land, to their own way of land ownership? Communal ownership, don't they have a right to have that recognized the same way that this white guy over here has a right to private property recognition? And in that case, in the Mabo 1, the Australian Supreme Court said, yeah, the Native people do have a right. And so if we're going to recognize that white person's right, we're going to discriminate against the Native people land tenure, the right to your ancestral lands. And they applied what was known as the International Convention on the Elimination of Racial Discrimination, and held in favor of Mr. Mabo and the Torres Strait Islanders. Groundbreaking decision. But they went just the opposite way of what the U.S. Supreme Court did on that. So recognized. One of the reasons why they did that is because they adopted this international treaty against racial discrimination into their domestic law. So when you take an international approach, you can recognize the rights of indigenous peoples collectively. But when you take a Western white approach, like comes out of the property law of England, then you only recognize individual property rights. And so this concept of destroying rights is what's called lawfare, or a war by law. And so what's happening is the judiciary now is waging war on Native people. It's been doing it for a long time, but it's really they're losing, they started losing in Congress. So now what oil companies and the plutocracy, the rich people are doing now is they're going into the courts and taking it over. So there's a couple of sites to journal articles and come out, like who's really behind Brackeen, white Christians are still taking Native children, and then why Gibson Dunn's best interest of the child has a dark side. So it's all being used as an excuse to destroy Native people. And so the second half of this, what's come up recently, and this is real recent, is that they're the same group, same lawyers, Gibson Dunn, are now getting together with the casinos in Nevada, the white casinos. And so they're saying, oh, well, we should be able, Native people have a casino in Washington State. They have them all over. And it's a multi-billion-dollar industry. Why should they have a casino on their reservation in Washington State where we can't have one in Seattle or some other place? That discriminates against white people. They're getting special privileges because they're Native. And so they're attacking Native sovereignty, because they're saying Native sovereignty should not defeat the federal government does not have the right to recognize Native sovereignty as having special rights over private interests, white people. And so they're attacking the Indian Gaming Regulatory Act. Now, if they win on that case, what they're asking that the courts throw out is the right of sovereignty. The right of sovereignty is a sovereignty that gives Native people the right to have gaming within their territory, whereas the state does not. That's why it's special. And what that'll do is if they destroy sovereignty, not only will it destroy Native gaming and the income that you're receiving from casinos, because what will happen is states will either ban it altogether because you'll lose your special right to have it, or they'll open it up and you'll have to share the profits. So either way, it's a lose-lose situation. But what they're really after is destroying Native sovereignty. And of course, the same law firm is doing this one. Okay, I had a couple of quick comments about the doctrine of discovery, and this is what Steve Newcomb talked about. This is the joint statement that was issued by the Catholic Church repudiating the doctrine of discovery. It was issued on March 23rd. And you'll notice there they say the doctrine of discovery is not part of the teaching of the Catholic Church. Well, that's kind of true. The doctrine of discovery is actually an international law doctrine that says if the land is empty and nobody has it, you can go live on it. I mean, the Lakota did that when they came from the Great Lakes and moved west, and they found some empty territory around the Missouri, and they settled there. Though Osage have that same kind of thing as a matter of law called the doctrine of discovery. Where the doctrine of discovery runs into trouble for us is because they apply it differently to Native people than they do to white people. They apply it differently to Natives than they do Christian people. So that's why Steve calls it the doctrine of Christian domination, right? Because what it says is that only white people can discover land and settle on it, white Christian people. And if you're not white Christian, then you have no right to the land. So that's a distortion of the doctrine of discovery under international law. And that distortion was made by the church when the church called Native people heathens and savages. And so this repudiation is false. And one way we can tell that it's false, as well as the whole doctrine of discovery argument is false, is that there was a second decision that came out of that Mabel case. It's Mabel number 2 up there in 1992. And what happened was the Australian Supreme Court took up the doctrine of discovery, and they said, oh, yeah, that's a long time ago. It's not fair. And they'd already issued Mabel 1 against the discrimination against Native people. And they said, yeah, doctrine of discovery is horrible. We don't agree with it. It treats Native people as savages, and so we're not going to go that way. So they tossed out the doctrine of discovery. Now, you would think if the doctrine of discovery is tossed out, then that would put you back to where you were before. It would pull the rug out from all the governments, all the governments of Europe, all the imperial nations of Europe, because that's what they base their claim on. Is that Native people cannot own their land because only whites can discover the land. And so if you throw that out, then they have no argument for the ownership of that land. Well, that's what happened in Mabo too. They tossed it. But what happened was, then the court goes on and rule, well, we're going to hold that the king has title anyway. Regardless, we're already here. And so they went ahead and recognized what they called the radical title of the king. It goes back to the feudal state. In England, when the king owned all the land and you couldn't own any land, you just got kind of like a life estate, or at least that's called a feud. They went back to that, and that's actually discussed in this opinion. So this unpacking radical title from sovereignty. So they were still able to compromise native sovereignty, even if they threw out the doctrine of discovery. And so if they throw out the doctrine of discovery here, I would predict that the U.S. Supreme Court would do the same damn thing. Which is why if you bring a doctrine of, Steve was saying, well, we got to go back to Supreme Court on the doctrine of discovery. I wouldn't hold my breath on that one. There's no way they're going to give up their ownership, the claim to ownership of native land. Now, what this ownership deal is, the federal government says that they own all the land under reservations, and that the people living on that land, that you've lived there for thousands of years, from time immemorial, forever, that you only have a right of occupation. You don't own the land that you're sitting on. That's the doctrine of discovery. If they get thrown out, then they're going to argue that some other rule of law, but they're never going to give up their ownership claim. So that's what we have looking down the road to come out. One of the things that show that the Catholic Church's repudiation is meaningless is because they issued the requiremento, which required everybody to become Christian or become a slave. And so that's the part where I want to end here. Now, before I move on to the next section, I'll try to speed this up a little bit because I know we're short on time, is I have to put in my caveat is I do this, as you know, don't trust me. I'm a Wasichu, I'm a lawyer, and I'm a man. And so you need to be careful with everything I say. From this point on, you need to question and think for yourselves on that. What I was telling you before is actually the way the law is. That's my expertise. I'm a lawyer, international law. I've been doing it for 40 years. I teach it at a university. That's the way the law is. And what Andrea was saying earlier about, for example, the declaration from 1974 and some of the other stuff, that's actually correct. And the Constitution and the treaties and all that, that is the law. The problem is that the federal government, the colonial power, simply perverts the law. So at this point, this is where you come in, and this is where you decide what to do. We have some friends now from Canada here that are facing this very question in terms of Canada's acting on signs of treaties, which is going to determine their sovereignty and their future. So you need to think about this. Now, under both this treaty, the International Covenant on Civil and Political Rights, as well as the UN Charter, and now particularly in the UN DRIP. And by the way, UN DRIP is enforceable. The way you use the UN DRIP is you use it to interpret other things. So when you want to know what this is a treaty, International Human Rights Treaty. When you want to know what this means when they talk about self-determination, how do you interpret that for Native people, for Indigenous peoples? You look here. And so you enforce the UN DRIP by using that other treaty, even though it's a declaration. So, and both of those have this statement here, that all peoples, so then the UN DRIP refers, adds the word indigenous to it. All indigenous peoples have the rights of self-determination. By virtue of that right, you freely determine your political status, right? Do you want to be independent? Do you want to be a confederation? Do you want to be a plurinational state? What do you want to be? Autonomous region? You freely determine your political status and so forth, all right? So now, IR governments are chartered by the federal government. They get their authority not from their inherent power, but from the federal government. The federal government actually says that, and if you read your constitutions, you'll see that in your own constitutions, that the authority comes from the Indian Reorganization Act, which means you're getting your authority from Congress. And so they're chartered by the colonizer under the trust and plenary powers. And so one of the ways that I would suggest that you deal with this issue, now these threats that we have coming down the line to sovereignty, is you have to repeal the IRA, because as long as you're under the IRA, you're under the control of the colonial power. And there's nothing tragic or devastating about repealing the IRA. There are plenty of non-IRA tribes that still get money from the government. They still get their contracts. They still exist, and they have their own constitutions. The IRA, repealing the IRA is not a death sentence. And you don't even have to change anything, really. You just go to your constitutions, and every time it says you have to get the approval of the Secretary of the Interior, you take it out. Just take it out. Just those few words. And I show you some examples for that. But anyway, so you got to repeal the IRA. Then the second thing you have to do is once you repeal the IRA and you actually become sovereign, once you repeal the IRA, your sovereignty comes from your inherent sovereignty, from the sovereignty you had before you were invaded, before the Wasichus came. You don't have that sovereignty yet. The treaty councils are trying to exercise that sovereignty. Tribal councils, if you're an IRA tribal council, you're not. Your sovereignty comes from the U.S. government. So once you get the U.S. government out of there, then you can start talking about inherent sovereignty, which then means you deal truly nation to nation. And how do you deal with that? You deal with treaties. In order to get into a treaty making thing, you have to repeal. In Canada, they still have treaties. They don't have this kind of law. In the United States, we have a law here saying no more treaties. So you got to repeal that. I think it's unconstitutional because I think it takes the treaty making authority away from the executive branch, from the president. So I think it can be challenged. And so here's a comment saying the IRA was the last great drive to assimilate the American Indian. And so once you repeal the IRA, and particularly if you can get rid of the 1871 Act on treaties, then you're under your own law. The law that governs here is not the BIA law. It's not federal Indian law. It's your own law. And so and this, I'm not telling you what to do. These are just suggestions. That's why I say don't trust me. Don't do what I say. Think for yourselves, all right? And so you can go back to restoring your traditional ways and your traditional governance, right? And I'm a fan, it's not an either or thing. I know IRA governments are threatened by this, or at least they seem to be threatened. It's been going on for a long time. I mean, I've been engaged in this debate and around it from the outside for 40 years now. I remember going to meetings at Oglala back in the late 70s on some of these same questions, right? So, but it doesn't have to be an IRA. It doesn't have to be an either or. One solution that I'm proposing, and I'm a lawyer, that's my job, is to try to propose legal solutions, is to have both. You can have tribal councils that are elected democratically, and they handle all the infrastructure, the roads and the schools, the business, the economy, healthcare, all of that. They handle all of that. But then when you get things that involve the tribe, the nation generally, the Chechichicoan, your traditions, the treaties, and so forth, then you have a treaty council, and that treaty council can be selected if you want by using the TOIA, TOSPAIA, OSPAIA. You have Nakchas that go in and you set that up, and they make decisions. If you got a decision on what to do about enforcing your land rights, right? That's not done by any one tribal council. That's the Chechichicoan. The 1851 and 1868 treaties were with the Chechichicoan. So you need a body to deal with that, and you can have those kinds of things. So they don't have to interfere with what's going on with tribal governments. No. And I think you can have both, frankly. But it's just how you want to set it up. So that's just the suggestions. Now, and once you get rid of that 1870, by the way, there's nothing preventing you from signing treaties with each other. The only thing the 1871 Act says is that the United States is not going to sign any treaties. It didn't say that native people can't sign treaties. You can sign treaty with. I'm an attorney with the Onondagas in a case before the Inter-American Commission, and I found out. Oh yeah, the Onondagas said, yeah, we met with the Oglalas and we signed a treaty with the Oglalas back in the 1970s. I go, oh, okay. And then I think our friends from Canada, I can't remember. Maybe somebody mentioned that there was another treaty signed, and there are other native nations have been signing treaties regardless. And so you can do that. So you start signing treaties, start defining your relationship between the 7 council fires and between the various reservations, and you can do that. So then you work nation to nation. Nation to nation just doesn't mean a native nation in the United States. It can be native nation, native nation. You can sign treaties with people down in Chile. You can the Mapuche. where you treaties of support and friendship. You can trade. Send Buffalo down there, and they can send back things that you need. Ramen? Namen. Okay, llamas. Yeah, you bring some llamas back up here. And the Yaquis, you know, you're right there, ready to make treaties. So, so there's treaty making, and one thing that's going on now, and is that there's treaty making. Once you can make the way that you should dealing with the federal government if you're truly a nation, is by treaty. And in Canada, they're still doing that. In New Zealand, they're still doing that. In Australia, they're still doing that. This 1871 Act is the barrier here, right? Once you get rid of that, then you can start doing things like this. Now, just May 3rd, which isn't very long ago, the Whitecap First Nation in Canada signed a treaty. It's 115 pages long, right? The good things about it is that generally they have their own IRA. It's called the Indian Act up in Canada. And one good thing about this treaty with the Whitecap Nation is that they got rid of most of the Indian Act, not all of it. They got rid of most of it, which helped them. They got their boundaries defined. They got self-governance in there and other things. You put a lot in 115 pages, right? The one thing they didn't do is they didn't pull themselves out from under Canada, right? And they did the opposite. By signing this treaty, they agreed that they're part of Canada, right? So if you sign a treaty, you may be presented with the issue about, are you going to decide to agree that you're part of the United States? And this is where I come in and say, this is your decision, not any lawyer's decision, not your tribal lawyer's decision, not anybody's, not NARF's, you know, not the National Congress of American Indians. It's nobody else's decision. It's yours as to what your status will be with the United States or any colonial power. And so this is where you get in. So you negotiate this treaty. And so that's what you need to do. You need to start negotiating treaties with the United States, where you start negotiating over the Black Hills. And that's how you solve these problems. And so you see these two, and they're Dakota nations. You know, one thing that's interesting is in this Whitecap Treaty is they state that they are part of the Oceti-Sakowin. It says in their treaty that they signed it. Why aren't you involved with the Whitecap Nation if they're going to sign a treaty that involves the Oceti-Sakowin? Are you part of the Oceti-Sakowin? Why aren't these treaty councils up there talking to them? And they're your relatives up there in Canada, obviously. The other thing that has to be done is not only do you get back your treaty making authority, but you have to repudiate the plenary power doctrine. You have to get rid of it. We don't recognize the plenary authority. And that's all based on the federal government claiming that you're incompetent savages. And that's the law today. You are incompetent savages according to federal Indian law to the government. You are not allowed to take care of your own affairs because you're incompetent. And that's where the trust relationship. So we're going to do it for you. Trust us. The trust us relationship. And as your guardians, as the great white father, we're going to make all the decisions for you for your own benefit, right? And that's the plenary power doctrine. And so you got to get rid of that. You repudiate that. And that plenary power doctrine was the basis of the 1871 Act. It was the basis of the 1877 Act, where they took the Black Hills. It was the basis of the 1880 when they broke up the Great Sioux Nation into reservations. All of that was done not by treaty, but by plenary power. So you got to reject that relationship. And so this is a case I'm working on right now with the Tribal Council for the Onondaga Nation before the Inter-American Commission on Human Rights. It's pending right now. And we are attacking the colonial relationship of the United States with the Onondagas. The Onondagas never agreed that they never agreed to the Indian Citizenship Act. They never agreed that they are citizens of the United States. They never agreed that they're saying, we never agreed to the colonial rule. You guys simply imposed it on us. And we had treaties that you were supposed to protect us, and you violated those treaties. So it's a treaty claim, and it's attacking the colonial relationship, saying it's international treaties, and under international law, you have to obey that treaty, and that treaty says you were supposed to protect us under international law. And so that's what we're doing there. And I'm working on that brief right now as we speak. And that involves land that they lost through the taking by the New York State and by others contamination of their lands and so forth. And they have a very, very small reservation left there. It's also brought not only on behalf of the Onondagas, but it's also brought on behalf of the Haudenosaunee, which is the Confederacy, the Iroquois Confederacy. And they had a confederacy very similar to the Chechichokan. And so you'll see that here. And so you got to redefine the relationship by treaty, resolve disputes like over the Black Hills. That should be done by treaty. And that's just my opinion as a lawyer. And so all of these things need to be renegotiated and resolved. And it can be done. So there are different ways that you can do that. Nation to nation, in between Native nations as well as DC. You know, it's interesting because, and Andrea was there. We were at the UN Permanent Forum on Indigenous Issues a couple of months, about a month or two ago. And it was a big deal because it was really the first in-person meeting since COVID of the entire group. And the Secretary General came up, opened it. We were in the big general, the General Assembly, the UN General Chambers, a big part of the UN building in New York, huge place, all filled up to capacity, standing room only. And Secretary General opens it and so forth. Deb Haaland, the Secretary in the air, gets up and also speaks. And she gives a pretty good speech on behalf of the US government and about what she's doing and all that. And then in the middle of her speech, she starts referring to government relations. And she said that several times, government to government relationships. I almost shouted out nation to nation, damn it. You know, even the executive order from Biden says nation to nation. We got to get around that. This is nation to nation, not government. So anyway. So yeah, deal with the law of nations, which is international law, should be controlled by the Vienna Convention on Treaties, not by the US Supreme Court, not by the Canadian Supreme Court, not by any colonial Supreme Court. Should control what happens with treaties between indigenous peoples. Last thing I want to mention is I'm also working with this group called, this organization called the Center for World Indigenous Studies. And one thing we're setting up is a new court, a new international court to hear claims by indigenous peoples, by nations. So right now, there's no place for indigenous peoples really to go for ethnocide and culturecide and genocide and those kinds of things. And so we made pretty good progress. There's been over 20 indigenous communities sign it. At one point, Armenia was getting ready to sponsor the court. And it was going to allow Native people to actually file claims against the offender. Instead of going to, by the way, all these international things, they were built and put together by the Wasichus. They were put together by the colonial powers. And over time, they've become more open, but there's still Wasichu venues, Wasichu courts. So the thing that we're trying to do with this new court is we're going to make it indigenous. It's going to recognize indigenous law. It's going to recognize indigenous procedure. It's going to recognize indigenous ways of doing Wolokota. So, and it'll recognize that at an equal or higher level than Western law. But that's a new thing we're trying. Anyway, my talk we listen. Open up. Thank you. I don't know how much time I'm eating it in everybody else's time. It's up to you guys. You want to answer a few questions? Okay. I got to appeal to higher authority over here. Yeah.
We'll go with Claude first and then President.
Me?
You got it on.
Testing 1, 2,
Okay.
1, 2.
Good afternoon. My name is Dar Waxaw and I'm with the Oglala Sioux tribe. And I wanted to put the issue on the ICWA. And the reason why I'm doing that is because we have already, the ones who who know what happened to us during the colonial, whatever you call it, with the Catholicism and stuff like that. You know, recently I was with some friends and they were from college. But they were good friends, you know, they didn't have no intentions of stealing children or anything. But the other thing with that is that the mother of these children didn't want the children. And the people said, well, we could take care of them if you allow us to. And so the mother said, go ahead, take them. So they took 3 children on their own. They took them back to Colorado. Okay, when they got down to Colorado, they were telling some friends of theirs, well, guess what? We don't have to adopt. They were just giving up. And that happens a lot, and their friends, they said, you can't do that. That's against the law. And they said, well, we don't think so because the Lakotas gave them to us. And I was like, oh my God. I said, do you guys know that's against the law? I said, you could go to jail for stealing kids. And that brings us back to when Catholicism was here, because I had to go to boarding school for 7 years of my life. And I had to stay there. And I was thinking, man, these people, don't people talk to them or whatever? Well, anyway, like a week or two later, they called me and said, Dar, what do you think? So I said, what'd you guys do? And that's what they told me. And I seen them the day before on the reservation. And somebody must have called them or something. And they said they took these kids willingly from the parents. And I said, you better talk to somebody down there, because if they catch you doing this without any kind of paperwork from the tribe, or I don't know if the state of South Dakota is even involved in ICWA stuff, And so apparently, they went to see a friend in Colorado, I don't know where. And they told them, you better take them back. It doesn't matter if they were given to you. You still had no permission, because in Colorado is different from the res, And I was kind of befuddled, because I was like, damn, so what are they supposed to do, And I was talking to other people, and eventually a lawyer got a hold of them and mentioned ICWA and that they were stolen kids. But I was like, how could they be stolen if they were given to them? I wanted some clarity on how that happens between families, not involving the law or even our judicial system, but other states and stuff, because eventually, about 2 weeks later, they brought the kids back. And the parents, they were like, why did you bring them back? We told you could have them. So was that against the law, or it's still happening? I'm aware of it, because this is what happened, and my friends got a hold of me, and that's what they shared.
That's absolutely against the law. It's child trafficking, which is different than the Indian Child Welfare Act. It's out and out. That's why they have missing Indigenous women and children, for example. Those are trafficking issues. It's criminal. So what they did was criminal. It's interesting, though, the issue that you raised is one of the 3 cases before the U.S. Supreme Court is a Native family that wanted to give up their child because they thought the child was in a better situation in the white family. And what that raises the issue is whose interests are involved. It's not just the child. The tribe has an interest in that. And so the court shouldn't be looking at, quote, the best interest of the child. They have to look at the whole picture. That child is the tribe's future. And the tribe has. And so those are decisions that need to be decided by the tribe, not some Wasatch state court, off reservation with some white family there with a lawyer and the Native people there without any lawyer. That's, it's just, even if the mom wants to give up the child, the tribe has to be involved in that because it affects the tribe. So that's where the sovereignty comes from. And that issue is before the court right now. And so in order for them to say, well, that was wrong for that Indian mother to give up that child without involving the tribe, they're going to have to say the tribe doesn't have any interest, that it's not sovereign. What if you were trying to adopt a kid from Mexico? Do you think Mexico has a right to their citizen to be adopted out in Texas across the border? No, you'd have to let Mexico be involved in that, and they'd have to tell you whether or not they're going to go along with that. You can't do that. So yeah, that's a good issue there. One thing I also on that case I want to know, I read all the briefs in the U.S. Supreme Court. Everyone filed an amicus brief. National Congress of American Indians, NARF, they got together. They got almost all the tribes to sign on. So I read their brief. They never mentioned genocide. They never mentioned the international law regarding the rights of women and children. They never mentioned human rights. They never mentioned ethnocide or cultural genocide, any of that. Not one of the 23 amicus briefs that were filed And none of the major briefs actually put sovereignty within an international law concept. And there was only one that was by the Lakota, what's it called? The Lakota Law Project, the one with Chase Arnice. Danny Sheehan wrote the amicus brief for that one. He did mention cultural genocide in passing, but no one in all those briefs made any of these arguments that I brought up here. And I offered to write the brief. I actually wrote the brief. I was working with, there might be some people in here with Everett Arnice and some others, and we were going to file that thing. And NARF calls me and begs me not to file it. They say, we don't want you raising genocide and talking about those things in the U.S. Supreme Court, because you're going to alienate them. You're going to make them angry at us. So they begged me not to file it. And they were representing 400 tribes. So I said, I can't file it. So, and a lot of those are the tribes that were here. Your tribe signed on to those briefs because you let NARF represent you in that. So what will happen then if the Supreme Court rules the way we think it will and throws out the NHL Welfare Act, then we still have the opportunity to file claims on an international level, like at this Inter-American Commission on Human Rights, and I'll be working with some people on that.
Two more questions and we're going to go on break.
Hopefully quick answers.
Okay, I'll be quick, sorry.
Hello. Questions, not opinions or comments. Questions.
This is Claude Tuelk, Chairman of the Sichangulu Lakota Treaty Council. Hello, Andy. The question I have in reference to what rights we have, and sometimes listening to what's coming and listening to our elders. In the past, growing up, when our way of life is being threatened, and the future generations of who we are, the concern of, in our Lakota way, we say, wo apre. And this wo apre that we have comes from the teachings, from inherent law. And what I've been reading and knowledgeable about, everything goes back to when we talk about treaty, congressional people listen to that. They listen to inherent law. And I've always been stressing the importance to our Ocheti Shakoi and other indigenous people. We need to really push our young people to go into law. We need to groom our people, the awareness of the seventh direction of who we are. One of the elders, and I heard that stressed so many times, is that our people are in that lost world majority. They call that Onunita Omane Palo. We need to find unity. We need to work on it. We need to find that law, the universal law of love. Love. It comes from love. And the courts that came across the water and is trying, the whole domination of the energy. Our grandfathers a long time ago, they called that a sickness. And that sickness is greed. We chokujong ovalo, there's a sickness coming to our people. And that greed is was done to our people from the East Coast to the West Coast. The same ones that murdered millions of our people and set themselves up as legislatures today are doing the same thing. The so-called criminals are now the lawmakers of our land. So, going back to how we as an Ocheti Shakoi, in defense of what we have that energy of unity, which again, in a more simpler term of using the Lakota word, wa'unshila. You know, the grandfathers and grandmothers long ago pitied us because it came from an energy that from the invisible world. And we all go into that energy called wonihincha. Wonihincha ake uwalo. There's a fear coming. There's a fear coming that's the future. What are we doing to prepare ourselves for the future? So with your expertise and helping explain how we can defend ourselves and keep the knowledge and the awareness of who we are, and finding that that unity. I remember listening to a council meeting, and there was so much sovereignty talk going on, and I was in college then, an undergrad, and I raised my hand and I said, how come, I was finally given the floor, and I said, how come we're talking about sovereignty and we should be concerned of our land base? We don't have a land base, then we don't have sovereignty. So these are the concerns, and how are we going to make the awareness of the long knives, what they took from us, and what we need to do. I always feel is that we need to test the water. We need to, I know there's some court battles that went on using the bad man clause and the 1868 Fort Laramie Treaty. They won. So I know this treaty has strength, and we need to educate ourselves more on that. I know the financial aspect of finding the right lawyers to do this. Listening to the court case of what we're talking about, the ICWA, man, they have some sharp lawyers. And what you're talking about, this Gibson and Dunn, or and what they're trying to do to our sovereignty. You know, we need to also find the lawyers such as yourself to find that unity amongst themselves to stand up for us. So that's what I wanted to ask, how we as a Ocheti Shakoi can look towards the future and finding those appropriate lawyers that are out there. And I'm also concerned about the financial aspect too. Thank you.
Or not, there we go. The Gibson Dunn lawyers, they have over 1,000 lawyers. The average salary, the average amount that each one is making over the last year is over $1 million, making $1,500,000 for 1,000 lawyers, 1,500 in their law firm. So that's how much they're netting, because they're getting all this oil money from oil lawyers. So that's what you're up against. And they're able to bring in all these things. They're able to fight that Dakota Access Standing Rock on that. So that's what you're up against. To answer your question, you don't need somebody like me. Preferably, you need somebody from your own community. You're all grandparents, right? Most of you. I'm a grandparent. Look for your kids and grandkids, then they're the future. And get them to on the right path, you know. We had those kids in here earlier and then they walked out. I suppose it was the class was over. You know, we have these colleges on most of these reservations. You know, start some classes in there and get them to show up and give them credit for showing up. Make that a class project. They get on a bus and they come down here and they sit in these treaty council meetings. That's their job. And then they write papers on it and stuff. They start learning the law. You get to them before they get to these white law schools. You teach them the way you want them to learn, not the way that the colonial power wants them to learn. You know, I've thought about in Colorado, we have the Fort Lewis College, and it's at an old fort, which was an Indian school down there, right? They still have their grounds. They still have some buildings and stuff. I wanted to start a law school down there for Native people, run by Native people. You need to get that, you know, what a crazy horse, he wanted to open a medical school for Native people. You gotta get a law school going on one of your reservations. Just open it and start giving out law degrees, and you get people in that you know who will teach it the way you want to teach it. But anyway, I hate to say it, but there's not many that think like me within the legal field, because they've all been brainwashed, frankly, and are paid off, or they think it's hopeless. Those three reasons. But anyway, thank you. Yeah.
All right, thank you. President Starr comes up.
All right. Quick.
I'll
More
try to,
questions?
I'll try to make this quick. I just wanted to, in reference to treaty tribes to government entities, that would be like the National Guard, FEMA, BIA. And also when you talk about nation to nation, that's treaty tribes to the government. For somebody who don't understand what that is, and we have exercised that. We have done it just recently, and it went straight to the president, and it was signed by the president, approved by the president. We exercised the nation to nation treaty right. It does work. So I encourage you, all the other tribes, your treaty tribes, to exercise that right. It does work, and the politicians in Washington, D.C. are realizing that. So I just wanted to pass that on. Hold on, Robert.
Oh,
A quick one. One more question, then we're done. Thank you.
Kilamaya. I just have a question regarding, my name is Deborah Tobacco, and I'm an Oglala Lakota. And my question is that, under international law, to what extent does a tribe have say-so over its tribal people regardless of where they live?
I'll get that back. When you leave the reservation, you're subject to the laws of wherever you are. If you go off the Oglala Nation territory and you go to France, you're subject to the law of France. So when you leave but you're still, it doesn't mean that you're a citizen of France. You're just subject to the laws. It should be the same work the other way too. You get Wasichu that come onto your territory. They should be subject to your law. So I'm talking all the way up to murder, whatever they get involved in. There should be no reason why you have to send things over to the federal court. And so that's the way it should work. Now, it doesn't work that way because you're under colonial rule, right? And so the other way, there are other laws that you might have that would control the relationship. They're called civil laws that might regard, let's say you have children overseas or whatever, that would involve the way that you define citizenship, things like that. Those are all subject to the laws, specific laws that you have for your people. Yeah.
My My purpose in asking that question was in regards to research. Is that the,
Oh, you mean like, intellectual property and things like that? Yeah, well, you have, that's all controlled by international law. So there's international law that controls culture, controls intellectual property, controls technology, things like that. And a lot of that law is still being developed. I think, Andrea's involved in some of that. But, for the intellectual property of native people, let's say your herbs and your knowledge of even climate change and things like that, how to deal with all that. That can all be protected under international law, but it's not totally protected right now. It's an area that's developing. I don't know how much farther we can. I think I need to end on this because I'm really running into other people's time. Thank you.